Please rise.
I can't.
Please be seated. This is People versus Pablo Forenza, 23T125. Mr. Forenza appears in custody. Mr. McCall is here for the people. Give me 1 second, I'm joining WebEx. I'm trying to. Mr. Forenza refused to stand before and
I can't stand. I'm shackled like a criminal over a traffic citation.
Before we even get into the courtroom today, let me set the stage for you. Because this case is a perfect example of how one bad decision can snowball into serious consequences. What started as a simple traffic citation turns into a full-blown contempt of court showdown, all because the defendant believed he could outsmart the system by refusing to participate. This is a classic sovereign citizen playbook. Challenge jurisdiction, file bizarre paperwork, and when things don't go your way, just walk out. But here's the problem nobody tells them. Courts don't just stop existing because you leave the room. This judge didn't chase theatrics. He followed procedure. And months later, that bench warrant came calling. Today, we're watching what happens when courtroom fantasy collides with legal reality. And trust me, the judge is not here to play games.
No, you're not here on a traffic citation. You're here on contempt.
Are we having a contempt hearing, Your Honor?
Well, I'm going to give you that opportunity. I'm going to advise you if you'd like it. Let me start by reading the relevant portions of the contempt rule, Mr. Forenza. This is Rule 407. This is of the rules of civil procedure, but that same rule applies to criminal actions such as this one. I'll read the relevant sections. Subsection A1, disorderly or disruptive behavior, a breach of the peace, boisterous conduct, or violent disturbance toward the court, or conduct that unreasonably interrupts the due course of judicial proceedings, behavior that obstructs the administration of justice, disobedience or resistance by any person to or interference with any lawful writ, process, or order of the court, or any other act or omission designated as contempt by the statutes of these rules. This will be direct contempt, and I will cover that in a second, but the rule is direct contempt is contempt that the court has seen or heard and is so extreme that no warning is necessary, or that has been repeated despite the court's warning to desist. Subsection 4 defines punitive sanctions for contempt, which includes punishment by an unconditional fine, fixed sentence of imprisonment, or both, for a conduct that is found to be offensive to the authority and dignity of the court. Most notably is subsection B, as in boy, which says addresses direct contempt proceedings. When a direct contempt is committed, it may be punished summarily. In such case, an order shall be made on the record in writing reciting the facts constituting that contempt, including a description of the person's conduct, a finding that the conduct was so extreme as that no warning was necessary, or the person's conduct was repeated after the court's warning to desist, and a finding that the conduct is offensive to the authority and dignity of the court. Prior to the imposition of sanctions, the person shall have the right to make a statement in mitigation. Mr. Forenza, I'm going to offer you that opportunity in a little bit. I make a specific finding that all conduct that I'm referencing occurred in my presence and therefore is direct contempt. Very specifically, let me make some reference. Mr. Forenza has been disrespectful to the court, to opposing counsel, and even to my clerks throughout the proceeding. He has filed spurious documents. He's made nonsensical arguments. He's been argumentative with the court, but I was willing to let all of that go so we could try the matter. On the day of trial, which I believe was November 24th, Mr. Forenza appeared on time, but stayed in the gallery along with who I believe is his wife. I repeatedly, at least 3 times, but perhaps 4 or 5, told him to approach the court, to cross the bar and sit at table so we could address the trial. Mr. Forenza failed to do so in my direct presence. He told me I had no jurisdiction, left the courtroom, and then amazingly was able to.
Right here is where the illusion completely collapses. The defendant wants to frame this as being shackled over a traffic ticket, but the judge immediately corrects the record. And that distinction matters. He's not in custody because of speeding or paperwork. He's in custody because he walked out of his own jury trial, ignored repeated lawful orders, and forced the court's hand. Contempt of court isn't symbolic, it's enforceable. And this moment is important because it shows the judge doing exactly what judges are supposed to do: clarify the charge, remove emotional framing, and anchor the hearing in facts. This is the moment the defendant realizes he's no longer arguing theory. He's dealing with consequences.
In any event, he has not returned since November 24th, other than a few pleadings that I'm guessing were filed that day or the day before. I've had no interaction with this case since November 24th. I make a finding that Mr. Forenza was under an order to perform, that is, to come to the table. He refused to perform in accordance with that order, and even though he had the ability to perform, obviously he was mobile, he was able to make it into the courtroom and then, of course, make it out. He was repeatedly warned, and I note that I gave him multiple opportunities to approach, and he disregarded all of them. I make a specific finding that I find Mr. Forenza's conduct to be offensive to the authority and dignity of the court. I make a specific finding that he engaged in misbehavior that rises to the level of obstruction of justice. The behavior happened in my presence. The conduct was intentional and willful, and these actions seriously affronted and disrupted the administration of justice. In that regard, I will note that I went and met with the 30 or so jurors who had appeared for the trial, that Mr. Forenza simply blew off. I had to explain why that happened, and I had to waste all of their time. I also wasted the time of the witnesses. Mr. Forenza, I didn't waste anybody. Mr. Forenza also wasted the time not only of the jurors, but of the witnesses, counsel, the court, and everyone else. The court finds him in direct contempt. I made a similar record on the morning of trial, but Mr. Forenza had bolted from the courtroom, and therefore I find he was not advised at that time, so at least not in any significant way, and I hereby advise him. I am considering a jail term for the contempt unrelated to the underlying charges, Mr. Forenza. I'm going to offer you some opportunities of how you want to proceed. First, if you wish, you can make the statement of mitigation right now, if you wish to. If you do not wish to, if you wish to consult with counsel, I will give you time to hire your own counsel, but you will remain in custody during the interim. I would even be open to the appointment of counsel if you believe you are indigent. In fact, I would appoint counsel if you were indigent. How would you like to proceed? And if you'd like a few moments to think about that, I'm fine with that.
Is that the only option is how I like to proceed, or can I make a statement?
Right, so I'm offering you option one and options 2 and 2A. Option 2A and 2B. Option 1 is you can make your statement of mitigation right now, right? And without counsel, the only person in the room other than court staff and the deputy is Mr. McCall. We are live streaming. You can make that. If you'd prefer, you can contact an attorney, and I will set this over for a time where you can make the argument through an attorney. Or appoint, that's 2A. And then 2B, if you believe you're indigent, I will appoint counsel.
Could you explain indigent, please?
This explanation from the judge is crucial because it dismantles one of the most common defenses people try to use in situations like this. Direct contempt means the misconduct happened right in front of the court. No investigation needed. No outside witnesses required. The judge personally saw it, heard it, and experienced the disruption. That's why warnings aren't always required, and why punishment can be immediate. Walking out of a trial, refusing to approach the bench, and declaring the court has no jurisdiction isn't protected speech, it's obstruction. And when the judge lays this out, he's not ranting. He's building a clean, appeal-proof record that explains exactly why sanctions are legally justified.
You don't have any money.
I'm sorry.
You meet the guidelines, you're in custody, and so I can appoint alternate defense counsel to represent you in the contempt proceeding if you are indigent. The actual language is in a Supreme Court guidance which says Colorado, I'll just read it to you. Colorado Rules of Civil Procedure 107 and 407 provide for the appointment of counsel to an indigent person cited for contempt where a jail sentence is contemplated. I am contemplating a jail sentence, Mr. Forenza. If the court appoints private counsel to prosecute a contempt action, which is not applicable here, or to represent an indigent party for contempt charges, that is relevant here, the judicial department will pay for counsel, as there is no statutory authority for the public defender or alternate defense counsel to represent clients for the sole purpose of contempt. But to qualify, you would have to be indigent, which means you would fit below the guidelines for public defender representation. If you wish, I can print those guidelines out for you.
Don't want to be represented.
I'm sorry, I couldn't hear.
I don't want to be represented.
Okay, and you understand that, and I will allow you to make the statement of mitigation right now, but you understand you do have a right to counsel.
The only way to look at it is I never got a fair trial walking into this. He failed to prove jurisdiction, sworn affidavit. The courts failed, personal, subject, territorial. I moved it to federal. I even had documents which I sent. It was ignored. Everything gets ignored. I'm just, you know what? I guess I'll just let you beat me up, throw me in jail, get it over with, because you can't keep me the rest of my life. And then, I'll deal with the consequences and things later. I mean, that's where I'm at.
Okay.
It's not right over a traffic citation where all I did is I came here in good faith to resolve the matter. And it was just, I could get nothing. There's no nature and cause of there. There's no sworn affidavit for me to even move forward on. And this court can't move forward on. That's all I asked for. And it was like retaliatory. I just got beat up. That's all this is. It's a traffic citation. It's not a crime. Nobody was injured. If that's, if that's what you call justice and fair, I'm not here to sit here and pick at anybody, go after, and that's not what it's about. When I posted bond for whatever it was, I came here and I didn't run. I came here to settle the matter. And that's all I wanted to do. And I just wanted a fair trial. That's it. But you get in my shoes, and how does it feel when you're just getting beat up and the judge you feel is being biased in the case? I mean, what do we do?
Notice what the judge does here. He doesn't focus on just one incident. He lays out a pattern of behavior. Spurious filings, nonsensical arguments, disrespect toward staff, opposing counsel, and the court itself. This matters because contempt isn't about hurt feelings. It's about undermining the administration of justice. The judge even acknowledges that he tolerated a lot more than he had to, just to give this defendant a fair trial. That detail is important because it destroys any later claim that the court was biased or impatient. The defendant wasn't silenced. He was indulged repeatedly. And when he finally crossed the line by refusing to participate, the consequences followed.
What else, Mr. Forenza?
Nothing else.
Mr. McCall, I should have asked you this before I moved to me. Is there anything that people want to say on this?
Your Honor, the people spent a good amount of time preparing for this trial. We actually brought the officer from across the state, met with him on the weekend beforehand to prepare for the trial. Officer Carnes was kindly enough, like I said, to drive on his own accord and his own expense to be here. He said he would come back for a retrial. He would request to be flown back, just given the type of the weather that it would be probably when it would be done. The people are still open to a plea agreement in this case for the traffic citations. We understand Mr. Forenza's stance as a sovereign citizen of what law he feels applies, but Your Honor, we believe that the traffic laws of Colorado apply in this case. We are more than willing to negotiate a plea agreement to this day. But at this point, Your Honor, that's where the people are, Your Honor. We didn't anticipate any jail in this case. We didn't anticipate anything but to paying the penalties for speeding 25 to 39 over on the Riverside Parkway back in 2023, and the failure license. Your Honor, the speeding ticket, I would even reduce it to 20 to 24 over to keep it in as a traffic infraction.
On the contempt.
On the contempt, oh, on the contempt, Your Honor. Your Honor, it's been an interesting case for me. I've never had a case that have gone this long with kind of like, the lack of being able to move forward. I've never been personally federally attempted to be sued in any case based upon a fee schedule. It finds it interesting that Mr. Forenza believes that contract law applies in this case, but only one way, his contract law. The issue here, Your Honor, on contempt, the people expended a lot of time on this case for a very minor case. I do not like putting someone in jail in this situation. I just don't know if Mr. Forenza will ever show up to a trial again in this case, for this case, or any case. He's done, a day or so in jail.
I'm not, anything else you want to say?
No, Your Honor, the people are, that's all the people are going to say.
Mr. Friends, I meant to ask Mr. McCall to make that statement before your statement. I forgot. If you'd like to make a statement to address anything he said, I'm happy to hear more.
Yes, I mean, I'm just objecting. I did, like I said, I came in good faith to settle the matter. And I tried. So it's not like I'm gonna skip town to that. That's not what it was. Because if I did that, I would skip town. Now, I didn't do that. I came here to put the court on notice, let them know it's in federal jurisdiction. That's what I did. And I stood my ground for that. I have rights, and it's not about my contract. That's not what it is. And him for saying it's contract, and that makes it a commercial matter. So I'm here to settle the matter. Set off and discharge, and as a secured party creditor, I have a right to do that. An attorney, in fact, representing the estate. So I would like to do that. Let's settle the matter. Let's just wash.
I'll give you an opportunity to resolve the matter, but we're talking about the contempt right now. I view the contempt as your direct and unequivocal disregard of the court's order. What would you like to say in mitigation of that?
Your Honor, it's not, like I said before, it has nothing to do with that. I wanted to settle the matter, and I feel like I'm running in circles, nowhere to turn, but who do I have to turn to? I'm trying to get this resolved, coming into court and hoping in good faith that you do the right thing, and it just didn't seem like it was going that way. I've never gotten any response to anything I've ever submitted, and that's what makes it hard. So how do you react to that? I mean, what do you do? Me and my situation, I'm scared. Okay, well, I have, torture cuffs and sitting here over a traffic citation. Missed my daughter's birthday yesterday.
This is the moment where everything crystallizes into a textbook FAFO scenario. 30 jurors showed up, witnesses prepared, an officer drove across the state, and one person decided none of that mattered. Courts take juror time extremely seriously because jury duty isn't optional. It's a civic obligation. When you waste that time, you're not just disrespecting the judge, you're disrespecting the public. That's why the judge emphasizes this so strongly. This wasn't harmless protest. It was disruption on a massive scale. And once jurors are involved, judges have very little tolerance for theatrics. This is the point where jail time becomes not just possible, but likely.
Anything else, Mr.
No.
Okay. Court finds the underlying offense can be resolved. As Mr. McCall points out, these cases are frequently resolved on the first appearance for a fine and be done. I find that Mr. Forenza, I don't know about negotiations. That's not my area But I find he has not litigated this in good faith. I find that he absolutely and unequivocally disregarded a repeated order of the court to come to the table on the morning of his trial. The remedy Mr. Forenza had would be to have the people try to prove their case beyond a reasonable doubt. He absolutely positively refused the court's order despite repeated statements. It follows up a long history of disrespect from Mr. Forenza towards the court, and more specifically, the entire judicial system. I find there to be no good faith by Mr. Forenza. I am not addressing the underlying case. I do note that there's a new speedy trial date in that case. That new speedy trial date is July 8th, 2026. I thought about rescheduling the trial today, but I'm not going to do that. I'll do that at Mr. Ferenza's next appearance. As to the contempt itself, and this is only as to the contempt, I note the difficulty. My plan was coming in to give 30 days jail, given Mr. Ferenza's statement of indicating of the difficulty this has caused him. I'll reduce that a little bit, but not much. This case, I hereby sentence Mr. For direct contempt. I sentence Mr. Ferenza to 25 days in jail. Furthermore, I set this matter for hearing on my next in custody docket I'll put him, though it's going to be a busy day, it doesn't make a lot of difference. Today's the 8th. Yeah, I want to set him in the next round. I'll set him on the Friday, January 23rd, 1 o'clock in the afternoon.
Your Honor,
We'll
I
set
have
trial at that time.
obligations and things I have to take care of. Can I post bail? I will be here.
This exchange perfectly illustrates how misunderstanding basic legal terms can seriously hurt your position. The judge is going out of his way to protect the defendant's rights, offering time to hire counsel, offering appointed counsel, explaining indigency in plain terms. And still, the defendant refuses representation. That's his right, but it's also a risk. Judges document these moments carefully, because later claims of unfairness fall apart when the record shows multiple opportunities were offered and declined. This isn't a trap. It's due process in real time. And the irony is, the more the court tries to help, the more the defendant interprets it as persecution.
So noted. I've sent you on the contempt, Mr. Ferenza. The next issue will be when I see you next time on the 23rd, right, is whether I should release you in custody on bond after the contempt sentence is over. There is a presumption that that you get a personal recognizance bond on a case like this for the underlying case, but that is overcome. And let me read you the language, because this is what you will have to address. I would recommend that you consider counsel. I have recommended that before. You have disregarded me, and that is in so many other things. The specific provision that is of concern to me, again, there's a presumptive personal recognizance bond. The arrested person has no ties to the jurisdiction of the court, reasonably sufficient to assure his or her appearance, and there's a substantial likelihood that he or she will fail to appear for trial if released upon his own personal recognizance. I will address the bond issue if you wish. The people are on notice that I am open to bond, but Mr. Ferenza will not be released until the 25 days
I feel like this is just retaliation more. And this is what I was afraid of at trial, Your Honor.
It's contempt, Mr.
This is what I was afraid of. But I wasn't in contempt. I showed in good faith.
Okay.
I didn't disrespect. I spoke the bare minimum just about jurisdiction. So everything you're saying is that's, your assumption that it didn't happen. I didn't.
Have a good day, Mr. Ferenza.
I have obligations.
Okay, you'll be able to address them upon release. Thank you.
How am I gonna do that here? I have obligations on the outside that I have to do.
Right. You'll be able to address those after your sentence is completed, Mr. Ferenza.